Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about a new ATF rule. And no, I'm not talking about the rule about what it means to be engaged in the business of being a firearms dealer. We've already talked about that one. No, I'm talking a whole brand new rule from the ATF. They are like the gift that keeps on giving. Now, here's the thing I want you to be aware of. This one is called the Bipartisan Safer Communities Act conforming regulations, once again made all possible by a piece of so-called bipartisan legislation. It is yet another chapter in a very long book now of the ATF just saying, you know what, let's just make some rules and change how the law works. So today, let's spend a few minutes, let's get you educated, and let's talk about the next way ATF will try to disarm you. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, here's what we're talking about today. We are talking about ATF Rule 2022R-09. This is a rule which is called the Bipartisan Safer Communities Act conforming regulations. And what this rule does, or at least what it purports to do, is change language in the CFRs to be consistent with the changes in federal regulations and statutes created by the Bipartisan Safer Communities Act. Now, this rule, much like the one about what it means to be an FFL and engaged in the business of being a firearms dealer, unlike the other rules that we talked about before, pistol braces, unfinished frames and receivers, bump stocks, etc., that had absolutely no statutory footing for which they could stand on. Yeah, this one's different because this one does have statutory footing to stand on because of the passage of the Bipartisan Safer Communities Act. Now, really important, when would this rule go into effect? According to the Department of Justice, the following. This final rule is effective on July 18th, 2024, unless ATF receives any significant adverse comment by May 20th, 2024. Okay, and I think this is important to point out that ATF is calling this a direct final rule, and because of that, they get to avoid a lot of the procedural mechanisms that are placed there by the Administrative Procedure Act. So your comment period is going to be significantly shorter, and the ability to actually stop this through comments becomes slightly more challenging. Now, according to the rulemaking order, if you want to make the appropriate type of comments that could theoretically alter the outcome of this rulemaking order, the following applies. ATF accepts comments from all interested persons. Pertinent to this direct final rule, a significant adverse comment is a comment in which the commenter explains why the rule, rather than the statutory language that the department is incorporating into ATF's regulation, is controversial or would be inappropriate, including challenges to the rule's underlying premise or approach, or would be ineffective or unacceptable without a change. And really, that's a polite way of saying ATF doesn't want you complaining about the statutory language, because if you want to complain about the statutory language, you need to call your representative to do that. You need to focus on how does ATF intend on implementing all of the things that come from the Bipartisan Safer Communities Act. Now, what exactly does this rule do? Well, it does a lot of things. According to the ATF, the Department of Justice is amending Bureau of Alcohol, Tobacco, Firearms, and Explosives regulations to implement firearm-related definitions and requirements established by the Bipartisan Safer Communities Act and the NICS Denial Notification Act. Among other provisions, The Bipartisan Safer Community Act requires enhanced background checks for firearm purchasers under 21 years old, addresses federal firearms license requirements, authorizes funding for state red flag laws and other crisis intervention programs, creates new federal offenses for firearms trafficking and straw purchases, and partially closes the boyfriend loophole, which previously excluded domestic violence offenses involving dating relationships from firearm restrictions that apply to spouses convicted of similar offenses. Okay, let's go through them in kind of rapid style fashion. Yes, if you are 18, 19, or 20 years old, this rule is going to significantly change the way you can purchase a firearm. Right now, if any of us 21 and older go to purchase a firearm and our background check is delayed, the FFL has the option, if they want to release the firearm to you after 3 days of it being delayed. However, if you are under the age of 21, there will be no ability for them to do that. They will have to hang on to the firearm for a minimum of 10 days. However, the Bipartisan Safety Community Act now provides that in the case of a person under 21 years old, if NICS notifies the FFL that the cause exists to further investigate possibly disqualifying juvenile records, an FFL may not transfer the firearm until 10 business days have elapsed since the FFL contacted NICS. Okay, the other thing that this is going to do is right now, if you go to a gun store and for whatever reason you are denied, there are some states where there are laws in place that require the FFL to immediately contact law enforcement. There are other states that have none of those measures in place whatsoever. Now, people get denied for one of two reasons. Number one, they should be denied, okay? Number two, I have seen people denied for simple clerical or paperwork errors. But here's the rub now. Under this new rule, if you are denied, every single law enforcement agency is going to be notified. And if you notice, they've changed the 44 or 73 to require more additional physical location information. Wonder why that is. This is how the rule reads. The NICS Denial Notification Act requires the Attorney General to report to applicable state, local, or tribal law enforcement and, where practicable, the relevant state, local, or tribal prosecutors if a person has attempted to acquire a firearm and has been denied pursuant to a NICS background check. NICS must provide such report within 24 hours after NICS denies a firearm transfer and includes the federal, state, local, or tribal prohibition, the date and time of the notice, the location of the licensee where the attempted firearm transfer was sought, and the person's identity. Okay, some of you may have not known this, but did you know that the Bipartisan Safety Communities Act actually amended part of 18 U.S.C. Section 922, which now brings a whole slew of juvenile offenses into the realm by which you can be disqualified from possessing a firearm, as the ATF writes in their own rule. As amended by the Bipartisan Safer Community Act, 18 U.S.C. 922D now specifies that events occurring when the person was a juvenile are disqualifying, except that the prohibition against the sale or disposition of firearms and ammunition to persons who have been adjudicated as mental defective or committed to any mental institution applies only to a person who were adjudicated or committed at 16 years of age or older. But a lot of you didn't know that. And a lot of you may have some old juvenile stuff that's kind of been free and clear, never ever bothered you in the past. Well, wait until you go purchase your next firearm because you may see these issues pop up. The rule also states, to conform to the statutory changes in the Bipartisan Safety Communities Act, this rule adds the phrase, including as a juvenile, to the end of the introductory language in 27 CFR 478.32D. This rule is also adding phrases at 16 years of age or older to the end of the paragraph. The Bipartisan Safer Communities Act also added new federal offenses for straw purchasing and trafficking in firearms, which I thought was illegal already, but apparently we needed more laws. According to the rulemaking order, the Bipartisan Safer Community Act added new offenses for straw purchasing of firearms and trafficking in firearms in 18 U.S.C. 932 and 933 respectively. And then finally, and this could turn out to be a really big deal, this closes what is known as the boyfriend loophole. Now, without getting too far into the woods, there are many, many domestic violence offenses that if a person is convicted, it will disqualify them from possessing a firearm. However, under federal law, what it took to be engaged in a domestic relationship such that the offense would be deemed domestic violence in nature was a little too constrained for the ATF's liking. So now, thanks to the Bipartisan Safer Communities Act, the ATF gets to broaden that definition. As they put it, the Bipartisan Safety Community Act revises pre-existing prohibitions against selling or disposing of a firearm or ammunition to a person who has been convicted of a misdemeanor crime of domestic violence and against such a person receiving or possessing a firearm or ammunition. Previously, the domestic violence prohibitions applied only to persons convicted of crimes committed by a current or former spouse, parent, or guardian of the victim, by a person sharing a child in common with the victim, by a person who is cohabitating with or has cohabitated with the victim as a spouse, parent, or guardian, or by a person similarly situated to a spouse, parent, or guardian of the victim. This left open the so-called boyfriend loophole because convictions for misdemeanor crimes of domestic violence against non-married dating partners who did not cohabitate or otherwise share a spouse-like relationship with the victim did not preclude the convicted person from receiving or possessing firearms or ammunition. So yes, this rule, which may seem rather innocuous at first glance, actually has the potential to create many, many more avenues by which otherwise lawful Americans can be disarmed. The rule, once again, the ATF rule is 2021R-09. We will link it up down below so that you can geek out on it for yourself. We will also link up all the information that you need to make a public comment. Remember, we have a short deadline. You only have until May 20th to make a public comment. Again, if you need more information, that's down there in the description box. And one last thing. If you guys ever have any ideas for a video, you're like, wow, I think Washington gun law should do that. Well, go ahead and click on that link right there and let us know, because some of the best videos we did weren't our ideas to begin with. Listen, if you got any other questions about this rule or anything else related to what's left of our Second Amendment rights, y'all should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Till next time, thanks for watching. Stay safe.